Hello and welcome to McKenzie Friend. Today we're going to look at medical consent and treatment in relation to family law matters. But first, a disclaimer. Whilst I hold a law degree majoring in family law, I have not sought admission or practice, so any advice cannot be relied upon. Specific questions should be directed towards an accredited family law specialist. Now, there's two situations. Either the child can give their own consent, or the decision is an element of equal shared parental responsibility. Now, certain states have acts which do allow a child of a certain age to consent to medical procedures, even if they're below the age of 18. They are listed here below. But we can look at the actual Family Law Act if the matter was to be brought in proceedings. So under 61C, each parent has parental responsibility subject to court orders, which means if the court has not made orders withdrawing parental responsibility from a parent, then parents have equal shared parental responsibility. This does not change if parents become separated or by either or both of them marrying or remarrying. So in absence of parenting orders, there is a common law responsibility to a child. This includes to protect your child from harm, to provide your child with necessaries, to financially support your child, to provide safety, supervision and control, to provide medical care, and to provide an education. Under Section 60CA, which is the foundation of the entire Family Law Act, the child's best interests are paramount consideration making a parenting order. You'll see this come up in many aspects of the Family Law Act, this issue of children's best interests. Right. What is the meaning of parental responsibility? We find that under Section 61B. In this part, parental responsibility in relation to a child means all the duties, powers, responsibilities and authority which by law parents have in relation to a child. 61D says a parenting order confers parental responsibility for a child on a person, but only to the extent to which the order confers on the person duties, powers, responsibilities, or authority in relation to the child. A parenting order in relation to a child does not take away or diminish any aspect of parental responsibility of a person for the child except to the extent expressly provided for in the order or necessary to give effect to the order. So if parental responsibility has not been taken away from a parent, they still have it. So let's look at specific orders relating to the welfare of the child under Section 67ZC. In addition to the jurisdiction that the court has under this part in relation to children, the court also has a jurisdiction to make orders relating to the welfare of children, and this can include medical issues. In deciding whether to make an order under subsection 1 in relation to a child, a court must regard the best interest of the child as the paramount consideration, as mentioned previously. Now, looking specifically at medical procedures, we need to look at the family law rules under revision 4.2.3. Under 4.08, application from a medical procedure. Any of the following persons can make a medical procedure application in relation to a child. That includes a parent of a child, a parent who has a parenting order in relation to the child, the independent children's lawyer, or any person concerned with the care, welfare, and development of the child. To support the application, if a medical procedure application is filed, evidence must be given to satisfy the court that the proposed medical procedure is in the best interest of the child. And the evidence must include evidence from a medical, psychological, or other relevant expert witness that establishes the following: the exact nature and purpose of the proposed medical procedure, the particular condition of the child for which the procedure is required, the likely long-term physical, social, and psychological effects on the child, and if the procedure is carried out, and if the procedure is not carried out, the nature and degree of any risks to the child from the procedure, and if alternative and less invasive treatment is available, the reason the procedure is recommended instead of alternative treatments, that the procedure is necessary for the welfare of the child, if the child is capable of making an informed decision about the procedure, whether the child agrees with the procedure, if the child is incapable of making an informed decision about the procedure, whether the child is currently incapable of making an informed decision, or is unlikely to develop sufficiently to be able to make an informed decision within the time in which the procedure should be carried out within the foreseeable future, and whether the child's parents or carer agree to the procedure. Now, we'll go and look at some case law now. This was basically settled in an English case that was also being upheld in the High Court. Now, in the Secretary, Department of Health and Community Services and JWB and SNB. It's called Mariners case, where they followed what Lord Scarman said in the House of Lords in England. A minor is capable of giving informed consent when he or she achieves a sufficient understanding and intelligence to enable him or her to understand fully what is proposed. In B&B, this approach, through lacking certainty of a fixed age rule, accords with experience and with psychology. It should be followed in this country as part of common law. Again, for a marriage case, the capacity to make an intelligent choice involving the ability to consider different options and consequences generally appears in a child somewhere between the ages of 11 and 14, though it might be rare. When we look at R&R, Baker J referred to the validity of the child's wishes inherent in will and should consider whether the wishes of the child are not unsound, founded upon improper considerations, or influenced by others. Justice Hammond's view in Doyle says weight should be given to the wishes soundly based and founded upon proper considerations and well thought through. In Segur and Segur, the court will attach varying degrees of weight to a child's stated wishes depending upon, amongst other factors, the strength and duration of their wishes, their basis, and the maturity of the child, including the degree of appreciation by the child of the factors involved in the issue before the court and their longer-term implications. Ultimately, the overall welfare of the child is the determinant. When determining the views, this must be undertaken by proper means. So that means it must be done without the influence of parents, and it must be generally held. So in conclusion, a child may have attained sufficient age or maturity to consent to their own medical treatment. If parents with equal shared parental responsibility cannot agree on medical treatment, then the court will decide based on the best interests of the child. The court will place reliance upon expert medical opinion. The court can either afford sole parental responsibility for health to one parent or make an order under Section 67ZC in accordance with Division 4.2.3 of the Family Court Rules. I hope this helps.